Good afternoon. I'm Andrew Hall, a Senior Claims Examiner at Medmarc. Today's presentation is titled Preserving Electronically Stored Information, Why It Matters and How to Protect Yourself. On behalf of Medmarc and today's presenters, Jason Waters and Kathleen Warren, thank you for joining us. Jason is a partner at Wilson Elser and an experienced trial attorney who has defended product liability, toxic tort, and commercial cases throughout the United States. He has significant courtroom experience and is adept at handling complex, high-risk cases, as well as managing large defense teams and prolonged litigation. Jason serves as Deputy Regional Managing Partner for Wilson Elser's Virginia office. In addition to his litigation practice, Jason has substantial experience managing the collection, review, and production of electronically stored information. He is a member of the Sedona Conference Working Group 1, which is a leading organization involved in developing principles, guidance, and best practice recommendations for, among other things, electronic discovery. Kathleen Warren is a partner in Wilson Elser's Washington, D.C. office. She concentrates her legal practice on complex civil litigation, including product liability, professional liability, and commercial liability cases. Her professional liability work includes the defense of medical negligence cases. Kathleen is also experienced in handling high-profile product liability cases in state and federal courts nationwide, including products liability matters in the life sciences arena. Kathleen has served as National Coordinating Counsel for a nationwide series of medical device cases and Monitoring Counsel for a putative medical device class action. With that, I am pleased to turn things over to Jason and Kathleen, who will begin today's presentation.
Thank you very much, Andy. It's a pleasure to be with you today. We really appreciate the opportunity to be here. We typically start out these presentations by reminding audiences that every case, no matter how large or small, no matter what the value is an e-discovery case. It's really become the experience of our team and for the last few years that that is true no matter how large or significant the matter is. When we first started looking at e-discovery cases, many people felt that these were a matter for large, complex litigation, mass tort, class actions, or MDL cases. But it was really brought home to me in the last week when I took on a pro bono matter in which the value of the case is no more than $1,000, but the most crucial evidence in the case are text messages between my client and the employer who owes her money. So it really has become the case that it's no longer electronic discovery. At this point, it really is discovery, and it has really revolutionized the world as we know it in litigation. We're going to cover several topics. We're going to give a brief overview of e-discovery and some issues that we hope people consider broadly as they look at any e-discovery problem. We'll talk about the duty to preserve, which is the most important aspect of what we're going to cover today. But we'll also talk about collection, review, and production, and we'll also conclude with some thoughts with respect to underwriting and claims management. When we're looking at e-discovery issues, we really ask people to consider two fundamental goals. And the first and most important is to stay out of trouble. And the best way to do this is to implement reasonable ESI preservation practices in how you preserve ESI, but also how you process it and produce it. And this isn't just about avoiding problems with the court, but it's also about making sure that we are upholding our obligations to our clients in terms of the professional obligations that the law imposes on us, but also meeting our professional and ethical obligations to the court as well as other parties with respect to candor with the tribunal and avoiding spoliation of evidence. But the second and most important practical goal is to minimize and control the costs. E-discovery has the very difficult but very accurate reputation of getting extremely expensive extremely quickly. And one of the most important aspects of effectively managing a large e-discovery portfolio is to identify the areas where you can, at the outset, control your costs and minimize your exposure, but also meet your obligations under the rules of procedure. As many of you have seen before, this is the what we call the EDRM, the Electronic Discovery Reference Model, and it basically takes the entire e-discovery world and compresses it into one image, beginning with a client's information governance procedures, and takes it through the identification of e-discovery issues, but also preservation and collection, processing, review, and analysis, and all the way through production and presentation to the court. We are primarily focused here today on the two middle categories, preservation and collection, as well as processing, review, and analysis. One of the things that we like to discuss when we're evaluating any e-discovery problem or a client's potential risk or possible escalation points, areas where there are particular triggers of concern, things that, like a preservation letter, when the other side, when a plaintiff or a claimant's attorney is telling you, I'm anticipating bringing a claim against your client, I'm asking you to preserve a variety of different evidence. And as many of us seen, these letters have gotten, can be extremely sophisticated and extraordinarily detailed, but they can also outline some extremely onerous, burdensome, and expensive preservation efforts that we would have to engage in to address those issues. And that's one of the issues when we see a preservation letter like that, it escalates the problem into something that we take very seriously. Also, anytime we see a potential threat with respect to spoliation, we appreciate that the other side may be looking at us and saying that they think that there's some sort of destruction of evidence and that there may be some sort of sanction that follows with regard to that. So again, it's something that we escalate whenever we hear any threats about spoliation. Discovery about discovery is a common tactic that we see where the other side asks us to conduct discovery about how we conducted discovery. So what they're asking here is they want to know information in either interrogatories or document production, how it was, what custodians did we identify, what documents did we produce, what was our procedure and process for meeting our e-discovery obligations. And again, this is very troublesome because it's trying to look behind the veil to ascertain whether there was any misconduct or a negligence in the e-discovery preservation aspect of a claim. Metadata requests are also very troubling because we're looking behind the information and not just the text that we see on the page. Adverse rulings are obviously escalation points because the court is getting involved in suggesting that there may be something untoward in how the e-discovery was handled. Elaborate e-discovery protocols being proposed by the other side are also escalation points because they highlight the seriousness of the situation. Another escalation point are abnormalities. When you're looking at a collection of e-discovery and you start to see things that shouldn't be there, like similarly situated custodians having a wide disparity in terms of the information that they have or the amount of data they have when you would expect them to be relatively equal. And turning now to the duty to preserve, one of the best definitions, in my opinion, of the duty to preserve and what triggers the duty, it actually comes from the Sedona Conference. And it's the reasonable anticipation of litigation arises when an organization is on notice of a credible probability that it will become involved in litigation. It seriously contemplates initiating litigation or when it takes specific actions to commence litigation. But there are a variety of different triggers, and it's not always driven by litigation that initiates a party's duty to preserve evidence. A variety of them include things like an unequivocal threat of litigation is obvious, but there are a variety of other things, such as a particularly catastrophic event or a cease and desist letter in the employment context, the escalation of a dispute to a legal department, or even perhaps supervisors discussing an incident of harassment. But this is an incredibly fact-sensitive assessment, and the most important aspect that we ask people to remember is that the duty to begin preservation efforts frequently arises before there's a claim letter or a lawsuit. And in the medical products context, Kathleen has some insight on that.
Yes, specifically in life sciences, the duty may be triggered by regulatory action, such as an FDA inquiry, or other governmental body that's begun looking into a drug or a device. There may also be a trigger by press about a particular device or a drug. The plaintiff's lawyers in the mass torts world are very well organized. They run a number of blogs and they host a number of conferences, and there are all kinds of emails that go around all the time about the new or next product that's going to be hot within the plaintiff's bar. Obviously, that would probably trigger a duty to preserve. If you find out that there have been lawsuits or claims against competitors with similar devices or similar drugs, that may trigger a duty to preserve as well. But as Jason said, in each instance, it's a fact-sensitive assessment that depends on the particular circumstances.
Yeah, unfortunately, it's not always a bright line test as to whether your duty has been triggered. And like Kathleen said, there's a variety of different instances depending on the particular client's circumstances or the insured circumstances that can suggest that either litigation or government action is likely such that the duty is already triggered. One thing that I've noticed in my own career, as an attorney and working with claims professionals, if the matter has hit our desk, there is probably already a duty to preserve. So I usually operate under the assumption that the duty has already been triggered and begin operating and start evaluating the specific circumstances from that presumption. And here are a long list of facts to consider that we use to evaluate this. And one of the things that I think that Kathleen was specifically talking about were that I think relate to the medical products industry is whether the company's learned of similar claims, the experience of the industry with respect to these claims, and the knowledge of litigation of similarly situated companies.
Yeah, so our experience has been that oftentimes when some of these mass tort lawsuits begin, or even for smaller groups of lawsuits, that the target is generally the biggest in the market to start with, and having a close collaboration among even competitors in a market can give you information about claims that are being made against them, and if there are similar drugs or devices within those companies, and those are circumstances to certainly consider preservation.
I was wondering about this in particular when we start to see advertising, because a lot of medical products seem to be the focus of attorney advertising. I'm assuming that that when we start to see this on TV, there's no question that the trigger's been pulled on the preservation duties because the purpose of the advertising is to generate clients.
Absolutely, that would be an absolute clear signal that there may be the reason to escalate for preservation purposes.
One of the things that we like to discuss generally with regard to whenever we're meeting with a client on an e-discovery situation is that there are an infinite and growing number of types of electronic discovery that we need to be considering. It's not simply emails, word processing, and PDFs anymore. We interact in the workplace with a variety of different applications, and there are numerous different data types that we're using on a daily basis, and all of this could be part of the discoverable world in terms of e-discovery. And a lot of times people don't necessarily appreciate that things like voicemails, for example, which are frequently transcribed through voice transcription, are now electronic discovery, or text messages between coworkers on even personally owned handheld devices can be electronic discovery. Instant messages can be electronic discovery that fall within the scope of your preservation duties. The metadata associated with files are things that we have to be considering preserving if it has a material bearing on the potential claim. So there's a variety of different types of ESI that we have to consider in each situation that we're looking at. There's also a variety in the same way of different locations of ESI. And this is where it becomes extremely important to understand your client, how your client operates its business, and what its information architecture is, and how its employees and the key custodians you're going to be looking into in a case interact with their company as well as their coworkers on a day-to-day basis. So, what type of server arrangement does the company have? Does the company operate in a cloud environment? Does the company use desktop PCs? Do its employees use their home PCs to do work? Do they use laptops? Do they use tablets to do their work? Or do they use their handheld or either company provided or their personal phones to do their work, and what type of data may be on there? Are there backup tapes or external hard drives what type of social media is the company using, and is there relevant information that might be shared via Twitter or Instagram or on Facebook or a variety of different resources that may be relevant. And this has been brought to home very, very importantly in a Virginia case where an attorney faced very severe reprimand in relation to the spoliation of social media that his client generated in the context of a wrongful death claim. So it's critical, and these lists are not intended to in any way be exhaustive, because every company and every party to litigation interacts electronically with the world around them in a variety of different ways. The point that we're making here is it is crucial to become extremely familiar with how your client operates in an electronic environment to understand what it is that you're going to need to preserve.
And another example of this that we have encountered in some of our cases in the medical device world is how important calendars are, especially when some of the issues that come up as part of the litigation is the interaction between the company and its customers in a device case, be it the hospital or particular doctors. Being able to identify when those interactions occurred and what those interactions are depends heavily on calendars. So if someone's using an electronic calendar, that needs to be maintained, and it becomes a relevant, discoverable issue for the lawsuit. In addition, as Jason said, there have been occasions where we have had to secure phones from different levels of employees at a particular company in order to obtain the text messages, because so much communication anymore is between customers and the companies on text message, and all of that is discoverable information.
Which highlights a significant problem when you're dealing with e-discovery, is that the characteristics of the information are such that it's easy to create, it's easy to destroy, it's extremely mobile, that the data can be routinely destroyed and deleted, and that there's a level of complexity when you're dealing with information architecture and identifying the various sources of e-discovery in any potential case. And all of this translates into some potentially extremely high costs that can be so extreme that they can be prohibitive to a party that is defending a meritorious claim. But the most significant issue when it comes to e-discovery that we've found is volume. When we're looking at volume, one of the things that we've learned and we've observed is that the volume of e-discovery in terms of what we're looking at in any given case almost seems to double every 18 to 24 months. And because there's so much communication electronically via text or email, and we are so dependent on our electronic communication, and it seems like every time we turn around, there's a new application that we're working with in terms of how we're interacting with our companies and our clients. The volume seems to be growing and growing and growing, and it doesn't seem to be slowing down. So the volume of it means that it can be extremely burdensome in the litigation, but it can also present some extraordinary challenges in reviewing and producing this material for discovery. So this all brings us down to identifying key e-discovery custodians in a particular claim. When the trigger has been pulled and we know we're under a duty to preserve electronically stored information, one of the first things you want to do is identify the key custodians that are the people who are going to have or likely to have discoverable, relevant information in the case. You can divide this into primary custodians and secondary custodians, but it's crucial to identify and to cast a wide net of the people who are likely to have relevant information and to interview them. So, you're asking yourself, are the individuals likely to be mentioned in the pleadings? Are they so important that the parties are probably going to identify them by name? Are the people that who are the people that are likely to be deposed in a case? Are they the people who designed the product, or are they the people who marketed the product? Or are they people who were involved in the regulatory approval process for the product? Are they identified or otherwise known to opposing counsel? What supervisory or leadership roles do they play? Also, we need to look at secondary custodians, people whose departments may be issued, or they may be administrative staff to key players. There's also critical to consider third parties. While the client may be one company, that company may have relationships by contract with others, vendors, for example, and those vendors may be under contractual obligation to preserve and maintain custody and control of information for the client itself. And the duty to preserve may extend to them as well, depending on their commercial relationships. And Kathleen has some examples of that.
Right, and specifically in a medical device case, it's important to think about the total manufacturing process for a particular device, because oftentimes companies will contract out for component parts of a particular device. So there may be third parties who have proprietary information of a particular insured or client that would be theoretically subject to the possession, custody, or control. And I also wanted to highlight something that Jason touched on, that in these kinds of cases, there can be allegations that touch many different departments. They could touch design departments, warning departments, marketing departments, regulatory departments, training departments, and then obviously sales departments. And that is a broad scope of discoverable information. Custodians are likely going to be relevant in all of those departments for any kind of life sciences case.
And again, the primary thing that we're looking at here is understanding your client's business, how it is it operates in an electronic environment, and what its mission is. Who are the key players? And in this respect, organizational charts in terms of departments and key personnel are invaluable. And as you become more and more familiar with the client, and every client is unique, you can formulate a plan and identify the correct custodians in order to put them under litigation holds. Which leads to the next topic in terms of some best practices. We talked a little bit about preservation letters. Obviously, when we see preservation letters from the other side, we have to react to them, evaluate, and we escalate them. We evaluate whether the information that they're seeking to have us preserve is reasonable, whether it's material that's relevant, or whether it's far beyond the pale in terms of the objectionable scope and the burden and expense associated with it. And we assert objections as appropriate when we receive preservations letters. But also with respect to custodians, it's important to issue litigation holds to make sure that we are documenting our preservation process. In addition to simply issuing a litigation hold, we have to conduct custodian and IT interviews. Once we've identified the custodians, put them under a litigation hold, it's important to actually meet them to discuss how it is they use electronic information in terms of what's needed to be preserved. It's critical to understand preservation policies, because each individual client or entity is going to have its own retention policies, whether they preserve e-discovery for 3 years or 7 years or even further, or they don't have any retention policy in place. It is critical to understand what their actual practices are, whether they're following them, and because it will help you to understand and define the scope of discovery. But it's also important to understand the idea of preserving in place and whether it's advisable under any particular situation. Frequently, a litigation hold will direct somebody to a custodian to preserve their own information, but in certain circumstances that may not be the best practice, given how the company operates in terms of its retention practices. For an example, certain companies' email may delete every 30 to 60 days, and the employee may not be able to preserve their own information with respect to that particular rule on their email account. So it's very important to understand how the company operates, or the entity operates, in terms of its retention policies. And the stakes are obviously extremely high. You can face monetary sanctions for failing to preserve appropriately. The court could issue an adverse inference or preclude you from raising an issue at trial. As I mentioned before, the failure to preserve social media in one key Virginia case resulted in significant disciplinary proceedings, and civil contempt has even been ordered. But the point that we make with our clients and with our attorneys is, don't let e-discovery derail a solid case that's otherwise winnable on the merits. We don't want to make a mistake in e-discovery, especially on the preservation side, that will compromise our defense. So it's very, very critical to ascertain and develop a plan for these issues early on. We're frequently asked about litigation holds in the context of our best practices. And sometimes people don't necessarily understand what they are, so we want to clarify that. A legal hold is a legal instruction. It usually comes from a risk manager or in-house counsel, and it is directed to the various custodians once you've identified who they are in a particular organization. And again, a litigation hold needs to be tailored to the particular circumstances of an individual case. It's not necessarily simply a form document you send out. You want to make sure that it's tailored to the issues in a particular claim. But it directs the custodians essentially to preserve relevant information that may be related to the claim. It discusses the allegations of the claim, and it gives them very specific instructions to preserve and cease routine deletion of data, assuming the custodian has the ability to do that. It also describes a category of information that needs to be preserved, and it's directed to both custodians and IT personnel. And the reason you want to do that is making sure that IT personnel, because they're key stakeholders in any e-discovery case, that they have an understanding that there's a litigation hold in place and that they need to be working with the risk management team as well as the client's attorneys to make sure that that they are preserving information in an appropriate way. But it's not simply enough to issue the litigation hold and presume that the various custodians are doing what they're supposed to be doing. It is critical to actively supervise the litigation hold once it's been issued. You want to confirm that you've issued it. You want the people who are the e-discovery custodians to acknowledge they've received it and that they are complying with it. Following up on the litigation hold is when you want to set up the custodian and IT interviews to essentially make sure that they are doing what they're supposed to be doing. You want to confirm with the IT department that routine deletion of emails, like the 30-day or 60-day email deletion cycle, has been suspended for a particular custodian. You want to monitor the compliance with the litigation hold to make sure that the custodians are, again, doing what they're supposed to. This is particularly important when you get a preservation situation that is months and months before litigation. You want to remind your e-discovery custodians that they're under a continuing obligation because the trigger's been pulled, even if the lawsuit hasn't yet been filed. And as you learn more information from doing your e-discovery interviews and meeting custodians and the IT department, you want to amend and reissue the hold because you're inevitably going to find out about new custodians who are going to be critical to the case or will have discoverable information, or the scope of the hold may change and you want to expand it or contract it or redefine it as appropriate. But this active supervision is something that's absolutely crucial. And what we're looking for here and what we're emphasizing is a defensible process. This defensive process idea is critical when anytime your e-discovery preservation methodology becomes the subject of a motion to compel or worse in the court with respect to what you've produced and how you produced it. So a documented, well thought out, strategic plan that shows active supervision of the e-discovery preservation plan is what we're looking for because it shows a very defensible process.
And one other thing to keep in mind is that although e-discovery is a well-recognized component of litigation in the United States, that's not true of other parts of the world. So if you have ESI maintained in another country, this is literally a foreign concept to them. And so there may need to be additional steps taken when ESI is maintained in other countries. And we would certainly recommend that the custodian interviews that are done or IT interviews that are done be done in person to the extent possible in order to get a clear understanding of the systems in place outside of the United States and also to be able to explain the process to those people outside the United States who have no familiarity with this kind of process or the litigation in total.
And the transactional action is the transactional the international nature of certain preservation issues also implicates privacy concerns that are different in foreign countries than they are in the United States. So it's, especially if you haven't insured perhaps a life sciences manufacturer that's in Europe, to escalate those issues whenever you see them, because they have a different understanding of the privacy implications with regard to e-discovery than we do here in the U.S. And like Kathleen said, it can be an extremely foreign and frankly invasive concept when you are implementing an e-discovery plan with a foreign client. And to emphasize the importance of maintaining and supervising the litigation hold and preservation efforts, there's a critical series of cases that was authored by Judge Shira Schindlin in the Southern District of New York. And Judge Schindlin is one of the best-known e-discovery judges. And in the Zubilate case, she wrote that a party cannot reasonably be trusted to receive the litigation hold instruction once and to fully comply with it without the active supervision of counsel. What this statement emphasizes is the absolute critical necessity of following up on a litigation hold and actively supervising it. We cannot simply issue the litigation hold and believe that all of our custodians are doing what they're supposed to be doing and that they're preserving information. It has to be an active plan from the moment the litigation hold is issued through the course of the litigation. And frequently during litigation, you need to remind ESI custodians of their continuing duty to preserve. During the custodian interviews themselves, there are a variety of different objectives. You want to confirm that the individual has a connection to the relevant issues in the case. You want to discuss email retention practices, and particularly with respect to if the custodian has the ability to delete their own data or set their own retention practice. You want to confirm how the individual custodian works electronically, if they're using an Outlook environment or they're using Gmail to do business, if they're using mobile phones and interacting with their colleagues via text message. You want to work with them to identify the time frame of their involvement as it relates to the scope of the allegations. But you also want to use them to identify additional custodians that may have information and, again, amend the scope of your hold.
So in addition, as Jason mentioned before, in terms of ESI that is stored outside of the United States, there are potential cross-border issues, especially with regard to privacy law. And so this is something you want to try to get a hold of at the time of the custodian interview, so you can understand the scope of the privacy issues that may come up. Depending on where else you are, especially in Europe, there may need to be major redactions for emails, especially with emails from the company to third parties. That is not commonly practiced in the United States, that kind of redaction, but anything that identifies a third party where there isn't consent may require redaction. You also need to seek the consent of actual custodians to produce information that's stored only in other countries depending on the privacy laws of that particular company. So those are all hurdles that you would like to address as early as possible because it will impact the costs later down the road.
With the IT individuals, it is critical to get out in front of the IT interview personnel as soon as possible to identify what the company's retention practices are. How is it that they're storing information? Is it on servers? Is it on the cloud? What are the locations, the enterprise locations that individuals who work for the company are operating from? One of the very helpful things with an IT department is to make sure to work with them to ensure that routine deletions are disabled and that you're documenting the deletion, the disabling of routine deletion cycles. Find out how they back up data and archive and journal data. And it's also very helpful to develop as soon as possible a data map. What is the information architecture for the client so that you can understand how individuals working within the system are operating on the enterprise applications. And so much of this is critical in many respects with regard to the proportionality concept. We frequently find ourselves, and I'm sure in the life sciences business as well as my own clients, where the discovery burden is asymmetrical. We're dealing with a plaintiff or a series of plaintiffs who have a very minimal discovery burden compared to our clients, and our clients' discovery burdens can be extraordinary. And we've seen situations where the tactics used by the other side are trying to take advantage of our asymmetrical discovery burden. As Professor Coffey noted, a litigation cost differential may sometimes enable plaintiffs' attorneys to engage in practices that resemble extortion. And we've seen these situations where the other side is trying to use our e-discovery burdens against us in such a way that it makes it so burdensome, so expensive, so difficult that the case may not be have the value to litigate. And this is built into the Federal Rules of Civil Procedure. Rule 26B2C3 lays out several proportionality factors that the court must consider. Whether the burden of or expense of proposed discovery outweighs the benefits considering the needs of the case, the amount in controversy, the parties' resources, the importance of the litigation and the issues. All of these are things that the factors that the court may consider in defining and limiting and controlling the scope of the parties' discovery obligations. And when it's a valuable tool to defendants or to parties in asymmetrical discovery where their burden is much greater than the other side's, to invoke the proportionality principle with the other side in terms of their initial discussions and their initial cooperative efforts to try to define the scope of discovery, to try to limit the cost and burden of these issues when it comes to discovery. Because if you're not able to do it in your meet and confer with counsel, or informally through discussions about what the scope of discovery will be, the court must consider these factors, and it is a valuable tool in the litigator's toolbox to invoke proportionality to early and meaningfully obtain reasonable control over this aspect of the litigation. One consideration to be very mindful of in this respect, however, is preservation is not specifically addressed in the rules with respect to proportionality. So we need to be extremely careful in a preservation context of saying, well, it's just not proportional for me to have to preserve this information. If you are going to invoke proportionality at that level, it is critically important to involve the other side in that and to make an attempt to cooperatively define the scope of your preservation efforts based on the anticipated cost and burden. But this is an important tool that helps parties legally maintain some control over the cost and burden of their e-discovery preservation. Moving on to collection, there are a couple of approaches. Obviously, the first approach is collect everything. And the problem with this is the cost is extraordinary and potentially far outweighs the needs of the case. The advantage of it is as a far greater defensibility aspect to it to basically indicate to the court that we preserved everything. The much more common but riskier approach is the targeted collection. There is a lower cost associated with it. There's certainly risk of having to repeat the process insofar as if a critique of the preservation practices reveals that the client didn't preserve enough information, missed custodians, or missed potential sources of data. And again, there's also a tremendous risk, as we said before, with respect to preserving in place, and it's something that needs to be considered very carefully depending on each individual client's circumstances. But what we're looking for in terms of the collection efforts, a targeted approach, is ways to reduce the scope and volume of data that we're looking at. And there are a variety of different ways, and many of which I'm sure most of you are familiar with. These in turn, keyword searches, limiting the number and identity and classification of custodians, limiting the date ranges for the collection efforts, using sampling methods to limit the scope of production, using software that will allow you to deduplicate, using deduplication software that will allow you to eliminate repetitious emails. The same with respect to email threading to collect single threads as opposed to each separate file. And one we'll talk about a bit more is predictive coding or technology-assisted review. With respect to review and production, this is the point where I'm sure many of you are familiar years ago, and still currently, we see rooms like this where rooms of attorneys or contract attorneys are going through documents and manually asking themselves whether they're responsive or non-responsive, and this is still a practice that many use because it involves attorneys and involves the actual review and manual review of the documents. But there are a variety of different ways to control this process and to limit costs associated with it. But when we're looking at a review, one of the things that we want to set review parameters very clearly and early on, and to make sure that we have, again, a plan with respect to the review process and how we're going to assess the information that we've preserved and collected. And that plan involves asking important questions such as, are we reviewing all files that have been collected? Are we only reviewing files that trigger certain search terms, or only reviewing files from certain custodians? And again, this will depend on a variety of different factors such as the volume of data and the number of custodians. Critically, it also involves the agreement and cooperation with counsel. If you can work with your other side cooperatively and productively to identify an approach to how the review is going to be conducted, it makes a much more defensible process when you have to address these issues with the court.
And specifically when you're talking about mass torts cases, to the extent you can try to get as many different plaintiffs' counsel on board with the scope of the review, of the collection efforts, of your whole process, to avoid having to redo them each time another lawsuit is filed or each time someone else comes on board, it will help you control costs in the long run. You do have a duty to try to cooperate with the other parties on these sorts of issues, and to the extent that you can do that early in the process, it will be beneficial. In addition, if you have ESI stored internationally, bringing those issues up with opposing counsel, informing them how you're going to handle it, and trying to work something out is much better than having to go to the court, who is more likely than not going to institute U.S. law over the privacy laws of any other country and provide you with a big problem with your client.
One thing I'd noticed in this, and Kathleen and I both discussed it, is that there's a tremendous emphasis on cooperation with respect to the other side when it comes to e-discovery issues. There's a Sedona publication called the Cooperation Principle. There are a variety of different cases that have addressed the cooperation and the importance of cooperation among counsel. And this all sounds nice, but in an adversarial world, this can be very, very difficult to do, and we've all seen very difficult opponents with respect to our efforts to meaningfully define the scope of discovery, especially when we find ourselves in a truly asymmetrical situation where the other side may want to take advantage of our discovery burdens. That said, in our experience, the courts truly look to counsel to work together to try to cooperate and to try to define the scope of discovery, to try to address preservation issues, to try to work out how discovery is going to be conducted and reviewed, as well as what the final format of production is going to be. The court would much rather work with attorneys who are at least making an effort, a demonstrable effort to cooperate with the other side in these respects. But we understand that that's not always possible. But it is important, as frequently being the producing party, to make a demonstrable effort to try to cooperate with counsel, but within that process to advocate for our position with respect to what really are the relevant issues in the case and how does e-discovery fit into that, what the burdens are in terms of production, and what's really truly going to be meaningful production with regard to the actual issues and evidence that gets admitted at trial. Because while in my own experience I've had a situation where we reviewed well more than 7 million pages of material, produced far more than 3 million pages of material, I doubt at the end of the day when we got to trial that the other side would have offered more than a couple thousand pages of that material and a couple hundred, well, I think it was about 600 exhibits. So at the end of the day, when you get to trial, it's a far less, the scope of the material is far less than what you started out with. So the efforts early on and to cooperate with counsel to advocate for a meaningful scope and control of the cost of these efforts will pay dividends to the court if you find yourself in a situation where the other side is totally unreasonable with respect to their demands and clearly attempting to take advantage of your cost burden with respect to discovery. In addition to setting review parameters, one of the issues that we like to emphasize, if you are choosing to go the manual review route, meaning that you've got a team of attorneys in a room reviewing documents and asking the question, is it discoverable or not, is it privileged or not, if they're going to manually be looking at a set of documents, it is critically important to train them, to make sure that they understand the cases they are working on and the issues that are involved in the case. Particularly in life sciences context, and I'll let Kathleen speak to this more, it doesn't serve you well to bring in a variety of different reviewers who don't understand the subject matter, either in terms of the legal context or the medical and scientific context.
Right. Some of these cases can be extremely complex, both legally and in terms of the science. And so having a well-prepared memorandum that outlines the issues for reviewers to be looking at, to have a good feel for the litigation, what's likely to be key issues as they're doing their review will pay dividends later on as the case unfolds and you have the materials that you need to properly defend the case.
Another issue that to address during a review such as this is to ensure that there's meaningful project supervision, that the attorneys who are supervising your reviewers understand the time constraints, that they are working with reviewers to track and monitor their progress through the review sets that they're getting, to help them move through it expeditiously, but also to ensure that they're doing it in a high-quality way such that the things that are being identified as responsive truly are responsive, and that materials that are not responsive are set aside and properly coded as such. A critical question with respect to any e-discovery situation that involves substantial volume is whether you need an e-discovery vendor or not. And this is a case-by-case assessment, and it really depends a large part on the complexity of the system architecture, the location and number of custodians, and the volume of e-discovery that you're looking at. But also you want to consider if the particular situation that you're in is particularly subject to a challenge to your process. And again, so much of this comes down to implementing, developing a defensible process that the other side and the court will understand that what you're doing is meaningful and appropriate and complying with the rules, and it's not done to avoid or shirk your responsibilities with respect to discovery. Predictive coding has emerged over the last few years as an extremely valuable tool in high-volume e-discovery situations. And it's one that has gained extremely broad support among the courts and e-discovery attorneys. What predictive coding is essentially is a computer algorithm that uses responses from attorneys with respect to the responsiveness or non-responsiveness of a particular set of documents to predict what other documents in that same set will be also responsive. So an attorney with knowledge of the case reviews a set of, say, 100 documents and categorizes them as being responsive or non-responsive. The algorithm uses those responses to run another set of documents, and the attorney looks at another 100 documents and codes them again, responsive or non-responsive. Then the algorithm operates again. Again, what the algorithm is doing is using statistical models to predict what documents are responsive and what documents are non-responsive. And as you continue to go through this process, as these iterative sets where the attorney reviews 100 documents or so, the program continues to return documents, and it gets better and better and better at the predictive modeling. And when you're satisfied that such a high percentage of the documents are responsive and that such a low percentage of responsive documents are finding their way into the non-responsive category, you can make your production that way, and it allows you to do this without having to have a manual reviewer go through every single file. And this, considering the volume of e-discovery, makes this an extremely valuable tool in terms of cost efficiency, but also in terms of its accuracy and reliability. And we've cited 3 cases here from the Southern District of New York in which the courts have embraced technology-assisted review or predictive coding as being an acceptable and even preferred methodology for e-discovery, large volume e-discovery cases. We should note that there's also been at least one instance in the Commonwealth of Virginia where a court embraced this as well, but there are a variety of other courts around the country that are adopting this technology, and it's becoming much more widely used and known by attorneys in the e-discovery world. Finally, with regard to production, it's important to develop a plan with regard to how you're going to be doing your production. Are you going to be doing a tiered production or a tiered review in terms of categorizing the importance of documents or the importance of custodians? What type of plan is in place for a privilege and confidentiality review? In this respect, it's important to ensure that you have a clawback agreement or that you have the ability to invoke the rules of federal evidence with respect to inadvertent production of confidential materials. Do you need to do additional custodians before you do your production, or perhaps redefine your search terms? Would a rolling production where you produce perhaps 500,000 files at a time be something that's preferable? Again, this is something that you can coordinate with counsel, but also critical in this is to make sure that everybody understands what the format of production is going to be, and that it either complies with your agreement or that it is consistent with the federal rules of civil procedure or whatever rules that you're operating under. I see we've used up our hour, and I want to thank you very much for the opportunity to speak with you, and we'd be glad to take any questions.
All right, thank you, Jason and Kathleen. I do have some questions here that have come in. The first question I got in is, how long are we required to preserve documents and emails of employees that are no longer with the company?
Well, it's generally a case-by-case situation that is dependent on the client themselves and their own operations. What's critically important here is to ensure that the client isn't setting up a document deletion procedure or a document retention procedure that is calculated to avoid their discovery obligation. Obviously, that would be an unreasonable approach to their document preservation, but it generally depends on their particular industry as well as their own information needs and storage capacity.
And also in the importance of the particular custodian with regard to the litigation issues. If they are a very important custodian, you'll probably want to preserve longer, depending on what the case is about.
Okay, and looks like we're probably going to only have time for one more of these questions. With storage of electronic information on the company server, is there a need for maintaining hard copy files? And if yes, can hard copy files be scanned and then stored electronically?
From an electronic discovery perspective, not necessarily a need to keep a separate hard copy of files. But it may, again, it depends on the enterprise operations of a particular client. If they have a need themselves to preserve hard copies of their electronic data, that's essentially up to them. But from an e-discovery perspective, it's not necessary to preserve a separate hard copy of it. When you get into the issue of scanning documents, the concern that you may have is that if you're scanning a document that was once originated as an electronic document, you will invariably be losing metadata, which can be the subject of discovery and your preservation obligation. So it is important not to discard metadata that could be discoverable in the case. But from an e-discovery perspective, it's not necessary to preserve a separate hard copy if the electronic version remains available and preserved.
Great. Thank you, Jason and Kathleen. You were able to cover a broad scope of material in a short period of time, and I know our listeners greatly appreciate your insight. So thank you for joining us. This concludes today's webinar.